First, welcome to the video. Today we will unpack how a sudden layoff can derail the green card process for professionals on long-term visas, particularly when the I-140 is approved and the I-485 is pending. We will focus on the critical 180-day rule, practical strategies, timelines, and risk mitigation. We will also cover AC21 portability, the consequences of a layoff before day 180, and self-sponsorship routes like EB2, NIW, and EB1. Finally, we will end with a clear summary and action steps. Next, let's set the context. Many highly skilled workers on L1A, H1B, or similar statuses may be far along in the green card process, with I-140 approved and I-485 pending. However, a layoff can jeopardize the entire process. The 180-day mark after filing the I-485 is a pivotal threshold under AC21. Crossing that mark unlocks portability and preserves your place in line. Failing to reach it, especially if the employer revokes the I-140, can invalidate the pending I-485 and force a reset, leading to years of delays. Meanwhile, here is our roadmap. We will cover the 180-day rule, AC21 portability, pre-180-day layoffs and resets, self-sponsorship options, concrete timelines, and mitigation strategies. We will also test your understanding with a few short quizzes. Before we go further, a brief disclaimer. This content is educational and not legal advice. Immigration outcomes vary based on individual facts, and you should consult a qualified immigration attorney for personalized guidance. Policies and adjudication standards can change, so always verify current USCIS guidance. Now, let's define the 180-day rule. If you have an approved I-140 and your I-485 has been pending for at least 180 days, AC21 portability is available. This means the green card application can continue even if you change employers, as long as the new role is in the same or similar occupational classification. The evaluation focuses on job duties, SOC codes, and wage levels rather than just job titles. This is the key lifeline that helps you avoid restarting the entire process. Next, visualize the critical timeline. At day 0, you file the I-485 after having an approved I-140. From day 1 through day 179, the case is vulnerable. If a layoff occurs and the employer revokes the I-140 during this window, the pending I-485 can be invalidated. At day 180, AC21 portability becomes available. After that point, you can move to a same or similar role with a new employer and continue the process without starting from scratch. The revocation risk is much more damaging before day 180 than after. Furthermore, the best-case scenario is to reach day 180 and invoke AC21 portability. Try to negotiate departure timing to cross the threshold. Prepare a new job offer that matches the same or similar occupational classification, and work with counsel to file Supplement J, when applicable, to confirm the job offer for portability. Simultaneously, maintain lawful status and preserve documentation such as pay records, job descriptions, SOC codes, and offer letters to substantiate the similarity of the roles and continuity. Consequently, if you receive a layoff notice, first confirm your I-485 filing date and compute the 180th day precisely. Next, ask your employer about the official termination date and whether there is a severance or notice period that could carry you past day 180. Then, promptly secure a job offer that fits the same or similar occupation and verify society code alignment and overlapping core duties. Coordinate filing of Supplement J, if applicable, and ensure you continue to maintain valid status. Finally, back up your file with evidence supporting the similarity of roles, including job postings, prior descriptions, performance reviews, and wage data. Now a quick knowledge check. The question is, when does AC21 portability typically become available for an I-485 applicant with an approved I-140? The options are 1. Immediately after I-485 filing, 2. At day 90 after I-485 filing, 3. At day 180 after I-485 filing, or 4. Only after receiving an EAD or Advance Parole Combo Card. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is at day 180, After I-485 filing, AC21 Portability generally becomes available once the I-485 has been pending for 180 days and the I-140 is approved. Next, let's compare paths. On the left, AC21 Portability allows you to keep your place in line after day 180, provided you move to a same or similar role. It is usually the fastest and least disruptive route. On the right, if the layoff hits before day 180 and the I-140 is revoked, the I-485 may be invalidated. The reset option requires obtaining a new non-immigrant status, such as H-1B or O-1, and starting a new PERM process, which can take years. Alternatively, self-sponsorship through EB-2 NIW or EB-1 can sever employer dependency, but it is more demanding and time-intensive to document and win. Then, consider the reset scenario. If a layoff occurs before day 180 and the employer revokes the I-140, the pending I-485 is likely invalidated. In that case, you need a new sponsor for a temporary status such as H-1B or O-1 and must restart the entire employment-based green card process. PERM labor certification, I-140, and then I-485. This often results in 3 to 5 or more years of delay and brings additional risks like H-1B cap timing, potential consular processing, and status gaps. Additionally, self-sponsorship options may be possible. The EB-2 National Interest Waiver requires demonstrating that your work has substantial merit and national importance, and that waiving the job offer and labor certification benefits the United States. EB-1A requires proof of sustained national or international acclaim across multiple evidentiary criteria, which is a high bar but does not require an employer. EB-1C is for multinational managers or executives and does require employer sponsorship, but can be powerful for those on L-1A with qualifying roles and corporate structures. Subsequently, let's quantify time and risk. AC21 after day 180 may take weeks to months to execute, with risks centered on proving same or similar roles and responding to potential requests for evidence. A reset before day 180 can stretch 3 to 5 or more years, with risks including visa caps, PERM audits, and status gaps. Self-sponsorship via NIW typically ranges from 6 to 18 months, while EB-1A may range from 6 to 12 months or longer, subject to evidence strength and processing variability. Now consider the decision tree. When a layoff notice arrives, first determine whether the I-485 has been pending for at least 180 days. If yes, pursue AC21 Portability by securing a same or similar job and filing Supplement J if required, thereby continuing with the existing I-485. If no, assess whether the employer will revoke the I-140. If they will, the I-485 is likely void, and you must reset by obtaining new non-immigrant status and restarting the PERM to I-140 to I-485 sequence. If they will not immediately revoke, explore negotiating the termination date to reach day 180, consider a rapid job transition, and coordinate with counsel. Furthermore, the Mindmap organizes risk mitigation. One branch covers dates. Calculate the I-485 day count, confirm the termination date, and determine whether a severance period might push you past day 180. Another branch covers documentation. Collect job descriptions, SOC codes, wage levels, and performance records. A third branch addresses the new employer. Align duties and society codes, and obtain a precise offer letter. The legal branch includes Supplement J, counsel strategy, and familiarity with portability guidance. The status branch reminds you to maintain valid non-immigrant status and consider travel implications. Finally, a contingencies branch highlights backup options like NIW, EB-1A, or O-1. Now, another quick quiz. If you are laid off before 180 days and your employer revokes your I-140, what is the likely consequence for your pending I-485? The options are: 1. It remains valid under AC21. 2. It is likely void and you must reset the process. 3. It automatically converts to a national interest waiver. Or 4. It pauses but resumes after you get a new job. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is that it is likely void and you must reset the process before day 180. If the employer revokes the I-140, the pending I-485 generally collapses and you must pursue a new sponsorship or a self-sponsored path. In summary, reach day 180 if at all possible. Line up a same or similar role and document the society code and core duties. If a layoff occurs before day 180 and the employer revokes the I-140, prepare for a reset. Consider NIW or EB1 as contingency pathways, recognizing the higher evidentiary standards. Throughout, coordinate closely with experienced immigration counsel. To conclude, AC21 portability, after 180 days, is typically the least disruptive path. By contrast, layoffs before day 180 can invalidate the pending I-485 if the I-140 is revoked, often forcing a reset. Resets can take years, while self-sponsorship may be viable for strong profiles with sufficient evidence. Ultimately, proactive planning around dates, documentation, and legal strategy is essential to protect your immigration timeline. As a final quick Markdown recap, remember that after 180 days from I-485 filing, AC21 portability becomes available. The new position must be in the same or similar occupational classification. If a layoff occurs before day 180 with I-140 revocation, a reset is likely. Backup routes include EB2, NIW, and EB1 categories. File Supplement J when applicable, and preserve robust documentation. Finally, thank you for watching. If this video helped, please like, share, and subscribe for more detailed guides. In the comments, let us know which path you would consider and why. Your experiences can help others navigating the same challenges.